Swayam Prabha. Digital India. Educated India.
Hello everyone, I am Dr. Shabnam Mehlawat, an Associate Professor from the Faculty of Law, University of Delhi. This is my lecture number 16 on the Mines and Minerals Regulation and Development Act 1957. Now this act was there at a time when our country gained independence and we had made various laws without having much development taking place in the country. So the laws which were framed were for protectionist policies for the reference to environment. The Mines and Minerals Act was a protectionist policy against the British government or an onslaught of the British government which were to make the protection more cautious for those who wish to exploit resources in our country. This act is an act for the development and regulation of the mines and the minerals under the control of the central government or the union. So this is, it relates to the environmental related activities in 1964 started way before all these international conventions came in. So this was in the first time in 1964 that the Convention for International Council for the Exploration of the Sea was felt when they started working on the problems and the issues which were related to environment as a result of industrialization. The world community formally started these issues in the form of a soft law which developed in 1972 under the Stockholm Declaration, which gave out principles which were 26 in number for protectionist laws to be framed in every country. For a period of 10 to 15 years, the protectionist measures continued till finally an action-based program or the Convention on Vienna Convention on Depletion of the Ozone Layer started, where chemicals had started completely destroying the ozone layer. So the natural resources which were meant to be of the land, air or water slowly and steadily were felt that these are being destroyed and depleted, and it was felt that there should be a law which should be working for the protection of environment. But in our country, it was way before in 1957, only when the law was drafted and when the Indian Constitution came into force, that this law was drafted and implemented. Societies had progressed leading to urbanization and industrialization. The demand for various mineral resources had increased. So the need was felt after witnessing the degraded state of environment, after the mining activity has been conducted, to opt for environmental protectionist laws and policies where it could channelize and protect those activities which need to be done for the protection of environment overall. So there was an abundant quantity and quality of minerals which were available naturally, and its deposition process is also natural and eternal. So there is no problem till the excessive mining started taking place at a level where the rate of extraction far exceeded the rate of replenishment. So as a result, the balance is tipped in favor of exploitation and not in favor of protection. Protection would only work where limited activities are allowed and only on a slow base scale and not an extensive scale to mine in areas where mining can take place. So India is a very rich country with rich mineral resources, and these different minerals can be found in various parts of our country. The dependency of the current day, which is on probably the oil, the petroleum, the iron ore, the gold mines, the oil industry, the shipping industry. These all require for their dependency on these mineral resources. The economies of country are mainly dependent on the petroleum, but later on, after the year 2012 and 15, people have started turning into for greener economies, with electric vehicles coming instead of petrol driven cars. So in India, our constitution defines our rights and liabilities, and under the constitution we frame our laws to protect whatever protection is required for the purpose of, and in this case under environmental laws, for the purpose of protection of environment, they have brought out various acts for the purpose of various protectionist acts which are required for certain resources to be protected. For mining purposes, we had the Mines and the Minerals Act of 1957, which had continued up till the 21st century, even till date. And the first amendments which took place after 1957 almost were in the year of 2015 and 2016. So the current law which I will be talking about, and we will be going over the provisions, is that we will be discussing the amendments after which the laws, how they have changed, and what is now required for the purpose of mining and extraction of minerals in various areas which have been classified under various schedules. So the Indian Constitution guarantees under Article 21 the right to life and personal liberty, which cannot be taken away by without the due process of law. This is also backed by Article 19(1)(g), which talks about the right to carry on your trade and profession, but that right to trade and profession cannot override the right to life. Then we have the directive principles of the state policy. These directive principles talk about the duties of the citizen, duties of the state, and it also talks about protection of our natural resources. So these fundamental rights, fundamental duties can be enforced by anybody who feels exploited or deprived by any law or any decisions taken by the government or otherwise, under the right to constitutional remedies under Article 32 and under Article 226. So this law, which is Mines and the Minerals Regulation and Development Act 1957, will be discussed with amendments of 2015 and 16. It declares the expediency of the union control in the interest of the general public, that the union or the central government shall take under its control the regulation of mines and the development of minerals. It was enacted by the Parliament in the 8th year of the Republic of India after India gained independence from the British rule. It is referred to only after the amendments have been made that a more focused law was brought about to clear the inhibitions which were prevailing since 1957. So the defining provisions go on to describe what is a composite license which is given to a person, an industry or a firm who is dealing with mining operations. It is the prospecting license cum mining lease, which is a two-stage concession granted for the purpose of undertaking prospective operations followed by mining operations in a seamless manner. Dispatch means the removal of minerals or products from the leased area and includes the consumption of minerals and products within such leased area. The exploration lease means the license which is granted under reconnaissance operations or prospective operations, or both, in respect of minerals in the 7th schedule. The government company will have the same definition as given under Section 2 of the Companies Act. The leased area now means area which is in the mining lease within which the mining operations can be undertaken, and includes the non-mineralized area required and approved for activities falling under the definition of mine as in the said clause. Minerals include all minerals except mineral oils, and minerals concession means a reconnaissance permit, prospecting license, mining lease, composite license, exploration license, or a combination of any of these with the expression concession shall be construed accordingly. The mineral oils which are left from the purview of the mines in the Mineral Acts are the natural gas and petroleum. The mining lease, it is a lease which is granted for the purpose of undertaking mining operations and includes a sub-lease granted for the same purpose. Mining operations are operations undertaken for the purpose of mining any mineral. The minor minerals include, it means building stones, gravel, ordinary clay, ordinary sand and other sand used for prescribed purposes. So basically India is also famous for sand mining and those activities which are both legally conducted by the government, and now it has taken is such a form that at times it is also illegally done. And there have been various cases and incidents in India where several dangerous situations have arisen because of the illegal mining activities. The notified minerals are any minerals which are specified in the 4th schedule. Prescribed means those rules which are prescribed under the Act. Production is a derivative of the word production, which means the mining or raising of mineral within the leased area for the processing or dispatch. Prospecting license means license which is granted for undertaking prospective operations. Prospective operations are undertaken for exploring, locating or proving mineral deposit in certain areas. How mineral is present, how much of the quantity is there, what is the status of a place, all that is taken into consideration while giving out licenses for the purpose of mining. So, reconnaissance operation means any operations undertaken for the preliminary prospecting of a mineral through regional, aerial, geophysical or geochemical surveys and geological mapping, including pitting, trenching, drilling and subsurface excavations. Now, these are all scientific activities which are carried out in a scientific manner. That is, the whole process involves certain decisions which is taken by the scientific community as to how protectionist mining activities can take place in mining areas. So, the schedule means those schedules which are appended under the Act. The special court means a court which is specially designated by as a special court under the provisions of section 30B. The mine and owner means the meaning as assigned under the Mines Act. So, the mine continues to be a mine till exhaustion of its mineable mineral reserve, and a mine may have different owners during different times from the grant of mining lease till the exhaustion of the mining reserve. The mining reserve, mineral reserve means the economically mineral part of a measured and indicated mineral resource. So, these are the defining aspects of the Mines and Minerals Act. Now comes the procedure or the prospecting or mining operations which are to be carried out under a lease or a license. This means that a person on his own, if he wishes to do mining operation or if he wishes to prospect any area or do prospective mining, he cannot do this on his own. He needs special permission from the government, apply in a proper form and manner as prescribed under the law. Only then his activity will be considered legal. Otherwise, that activity which he does on his own without notifying the government is considered to be an illegal activity. So, prospecting or mining operations to be under a license or a lease, a person shall undertake the same of reconnaissance, prospecting, mining in any area and in accordance with the terms and conditions of the permit or a license, or as the case may be of a mining lease granted under this Act and the rules which are made thereunder. The rules and regulations go on to prescribe the manner in which a person might make an application, how that application then is taken up by the authorities. It is seen from all aspects, from the scientific aspect as well as other legal procedures, and if they wish to accept the same, they will accept it, and if on certain conditions and reasons they wish to reject it, they would be rejecting it. However, he would be given an opportunity of being heard as to why his application should be accepted for the purpose of mining. The proviso says that leases before the Act for mining granted before the commencement of the Act will remain unchanged. That is, those activities which were done for the mining purposes, they will continue. This is a clause which was there in 1957, that those areas where mining was permitted and going on, they had got licenses for the purpose of mining, will continue, but after the Act comes into force, that mining aspect would be changed. Nothing in this subsection shall apply to prospective operations undertaken by the Geological Survey of India, the Indian Bureau of Mines, the Atomic Minerals Director for Exploration and Research, Department of Atomic Energy of the central government, Directorate of Mining and Geology of any state government, the Mining Exploration Corporation Limited, and a government company within the meaning of the Companies Act. Any other entities, including private entities, that may be notified for this purpose or as may be specified by the central government, and specific mention of non-application to previous leases in the Union Territory of Goa, Daman and Diu have been made. Then comes the transport, the storage and termination of prospective mining in areas. Now, areas which are new or are discovered for the sake of mining, their licenses are granted and a proper procedure takes place for the purpose of mining. These activities, when they are carried out, they are to be monitored, and the moment they are monitored, they can be identified as a legal mining or an illegal mining. After the mining activity has been over or the mineral has been exhausted, then that transportation or storage of that mineral might take place. So, what are the aspects related to the same are that no person shall transport or store or cause to be transported or stored any mineral other than in accordance with the provisions of the Act and the rules made thereunder. Any state may, after consultation with the central government made under section 18, undertake reconnaissance, prospecting or mining operations with respect to any minerals specified in the first schedule in any area and which is not already held under the mineral concession. The termination of prospecting, mining and other leases, it can be done even prematurely of any area or any areas where, after the consultation with the central government or the state government as the case may be, it is expedient in the interest of regulation of mines, mineral development, preservation of natural environment, control of floods, prevention of pollution, or to avoid danger to public health or communications, or to ensure the safety of a building, monuments or other structures, or for the conservation of mineral resources. For example, if mining takes place, say, in an area A, after half the mining is done, they encounter certain natural forces which would be completely destroying the area in case the mining is asked to be completed. Then in those cases, the government may ask for stopping of these mining activities in such areas for the protection of environment and so that further deterioration does not take place. It will only be done after an opportunity of hearing is given to the leaseholder, where the holder of a mining lease fails to undertake production and dispatch for a period of 2 years, and after the date of execution of the lease or having commenced the lease shall lapse after the expiry of the 2 years from the date of execution of the lease, or as the case may be. The government shall do so and record the reasons in writing for extending or revoking an application. It may also extend, let us say, an area A has been used for mining and it requires a few more months to continue mining for the purpose of extraction of the entire material, which is not detrimental to the environment. In that case, the government may allow the expansion of period of time, but it shall not go beyond a period of 3 years. Conditions for efficiency in production and restrictions on grant of mineral concession. Conditions for efficiency of production are, notwithstanding anything in the provisions of 4A, the central government may, in the interest of maintaining sustained production of minerals, that is important, in the country, prescribe the conditions as are necessary for the continuation and commencement of production by the holders of mining leases who have acquired rights, approvals, clearances and the likes under section 8B. So, the restrictions on grant of mineral concession, where a state government shall not grant a mineral concession to any person unless the person is an Indian national or is a company registered under the Companies Act and satisfies the conditions as are prescribed by the government or the state government may say, then in that case the restrictions are placed on the grant of concession. The first schedule requires for part A and for part B reconnaissance permit, a license, a mining license, which is to be granted with the previous approval of the central government. First schedule for part A, the previous approval of the central government is not required for grant of mineral concession for minerals. An allocation order has to be issued by the central government under section 11A, subsection 1A, subsection 2 of 17A. Or vesting an order or allotment order has been issued by the central government under the provision of Coal Mines Act 2015. India's dependency on the use of coke and coal is enormous, and it is here where the deterioration takes place, and it is here where the maximum pollution under other laws takes place. So, under section 5, it is the eligibility and grant of a lease. For the purpose of explanatory aspect, the person who is deemed to be an Indian national in a firm or other association of individuals only if all the members of the firm or association are citizens of India, and in the case of an individual, he himself has to be a citizen of India. The composite license or the mining lease is granted for an area other than the government company or corporation in respect of any minerals specified in part B of the schedule, where the grade of such mineral in such area is equal to or above the threshold value which may be notified by the central government. The mining lease is granted by a state government if it is satisfied that the application made shows evidence of the existence of a mineral content in a specific area and is made in accordance to the parameters as is prescribed by the central government, and the mining plan is duly approved by the respective central government or the state government for such category of mines. The plan is filed in accordance with the system established by the state government for the preparation, certification and monitoring of such plan, and with the approval of the central government. The mineral concession of an area, section 6 provides the provisions for obtaining mineral concession for an area. The maximum area for which a mineral concession may be granted is one of the more prospects, which is a total area of more than 25 square kilometers or 1000 square kilometers, which has been made in the current 2023 amendment. The area granted under single reconnaissance permit shall not exceed 5000 square kilometers or more exploration license covering a total area of 5000 square kilometers. The area granted under a single exploration shall not exceed 1000 square kilometers or one or more mining leases covering a total more than 10 square kilometers. If the central government is of the opinion that increasing an area for reasons which are recorded in writing is in the best interest for the development of the mineral or any industry, it is necessary to do so. If it does so, then to any particular mineral or any specified category of deposits which is not contact or contagious in any particular area. The person acquiring by or in the name of another person who is a member of a cooperative society, company or corporation or a Hindu undivided family or a partner in a firm, a mineral concession is deemed to be acquiring it himself, where his share from the total area will be deducted, and so that the total allocated area is not exceeded from those limits which are permitted. The time period of the lease. The time period of the lease may be granted or renewed are reconnaissance permit, the license for not exceeding 3 years. A prospective license, the time required with the prior state government approval for a specified period should not exceed 5 years. Provided further that no prospecting license granted in respect of a mineral included in Part A and Part B to the first schedule will be done by the central government. Under Section 8, periods for which mining license may be granted or renewed are for minerals specified in Part A of the schedule from 20 to 30 years, with the previous approval of the central government depending on from case to case, from the period when it starts till the period it might be extended. In case of government companies or corporations, the period of mining lease includes the existing mining lease or as shall be prescribed by the central government and granted by auctions only. Now, the current leases will go by auctions with the amount which needs to be paid and an additional fees for additional amounts which shall be notified by the government in the official gazette. Where coal or lignite is used for captive purposes such as coal or lignite will be up to 50%, and in cases of increase will be notified. It will not be allocated to those companies which have been awarded mega power projects. Section 8A provides for grant of a mining lease for minerals other than coal, lignite and atomic minerals will be for a period of 50 years, and modifications may be made by the government by notifications of the details in the official gazette. The provisions of these shall not apply to a mining lease granted before the commencement of the Mines and the Minerals Amendment Act 2015, for which renewal has been rejected or has been determined or has lapsed. Transfer of statutory clearance and payment of royalty. Now, those who are extracting mine and minerals firstly need to apply in a proper manner, pay a fees and pay additional fees if an additional mining has taken place. And for making use of those mines, they need to pay a royalty and a fee for making use of that mineral, for turning it into a usable product and for other like related activities in case it is a mineral for which the process of Mines Act has been applied. So, the provisions for period and transfer of statutory lease for valid rights, approvals, clearances, licenses and the like granted to a lessee in respect of a mine other than those which are granted under the Atomic Energy Act 1962 and the rules which are made thereunder, it shall continue to be valid even after the expiry or termination of the lease, and all rights will be passed to the successful bidder of such rights. The person who has taken up a lease previously and the person who bids for that lease later on, the person who had enjoyed the first provisions will also be enjoyed by his successive person who comes forward for the purpose of that lease. An expiry of such lease period, the government may grant leave to a government company or a corporation for a period not exceeding 10 years or till selection of a new lease through auction, whichever is earlier, or who will acquire similar rights as per the previous holders. Then come the royalties. Royalties in respect of mining leases, where the holder of a mining lease granted before the commencement of this Act and notwithstanding anything contained in the instrument of the lease for the time being in force, pay royalty in respect of any mineral removed or consumed by him or his agent or manager, employee or any other person under him from the leased area. Then he shall be paying that royalty at the rate which is specified in the second schedule in respect of that mineral. He shall not be liable to pay royalty in respect of any coal which is consumed by a workman engaged in a corollary, provided that such consumption by the workman does not exceed 1/3 of a ton per month. The rate may be enhanced or reduced by the government from time to time, but not before 3 years of this Act. Then there is a provision called the dead rent, which is to be paid by a lessee. It is specified in the third schedule. For all those areas included in the instrument of the lease, where the holder of such mining lease becomes liable under Section 9 to pay royalty or the dead rent, whichever is higher for any mineral removed or consumed by him. The government may increase the dead rent after every 5 years. The District Mineral Foundation, the district mineral foundation in any district may be, it's a non-profit body, it may be formed, and the district affected by mining related activities, the state government shall establish a trust, a non-profit body, where its objective will be to work for the interest and benefit of persons and areas affected by the mining related operations in such a manner as may be prescribed by the state government. It has prescribed functions, and the state government may give directions for the utilization of these funds. The holder of a mining lease will pay royalty and additional money to the foundation as may be prescribed. Then comes the National Mineral Exploration Trust. It is a non-profit autonomous body, and it is called National Mineral Exploration Trust, which was established by the central government, who will utilize the funds for the purpose of regional and detailed exploration in such a manner as may be prescribed. The holder of a mining lease or a mineral concession shall pay to the trust a sum equivalent to 2% of the royalty paid in terms of the second schedule. When we look at the second schedules, when we are reading these provisions, we get to know immediately under the second schedule what amount needs to be paid for what kind of mineral. So, the National Mineral Exploration Trust is a non-profit autonomous body. This is another trust which is established by the central government. It will utilize the funds for the purpose of regional and detailed exploration in such a manner as may be prescribed by the central government. The holder of a mining lease of a mineral concession shall pay to the trust a sum equivalent to 2% of the royalty paid under second schedule. Then, what is the procedure for obtaining mineral concessions in respect of the land in which the minerals are vested in the government? An application needs to be made in a prescribed form with prescribed fees for the acknowledgement by the government. The government may grant the approval, the government may refuse to grant that approval, depending on from case to case, depending on several other factors involving that mineral. That is, if it is a rare mineral, then it may not allow further extension to take place, and if it is a rare mineral, even in middle of the mining activity, they may disallow to continue the said activity, for it may be detrimental for others. The Mines and Minerals Act is also interrelated to certain other laws like the Indian Forest Act, the Wildlife Protection Act, and the Forest Dwellers Act, or the Scheduled Tribes and the Forest Dwellers Act, which goes for protection of the rights of the forest dwellers or the scheduled tribes. So, in this manner, the fees which is collected from the mining activities, royalty may be asked to pay to these forest dwellers for taking away the rights of their lands to assigning them for a different activity. So, under section 10A, 10B, 11A, 11B or D, or selected under the Coal Mines Provisions Act, this selection is done in accordance with the procedure given out by these sections. The right of the existing concession holders and applicants, the previous application when it becomes ineligible before 2015 amendment, the remaining rights would be granted by way of auctions by the prescribed procedure. Then there is the granting of a mining lease in respect of notified minerals. It is again through auctions and lapses, and further lease will be granted according to the procedure which has been prescribed by the central government. 10BA goes for grant of exploration of license for minerals which are specified in the 7th schedule through an auction. Then the procedure for obtaining concessions. There is a grant of a composite license through the auction in respect of minerals other than the notified minerals. That is, a person needs to make an application in the prescribed form and the prescribed manner, which will be accompanied by a prescribed fee which is stated by the central government. After sending in the application, the government will look into those matters of granting leases, If they are satisfied with all the application provisions and all the activities as promoted by the applicant, they might be accepted, or they might be rejected or refused on certain grounds which the government needs to give in writing, and they need to also ask or give a hearing, an opportunity of hearing to the person who is applying as to why his lease should not be rejected. The granting of mineral concession of a composite lease in respect of coal or lignite again follows a similar procedure. Then there are powers of the central government to make rules for regulating atomic minerals specified under Part B of the first schedule. So, atomic minerals, when they are to be used, the government may make rules and regulations and prescribe forms in which certain minerals may be extracted or certain minerals may be made use of. The ultimate decision first comes from the constitutional law. It is then brought about by the exact law related to a particular activity, and under that law the government may make rules and procedures for the purpose of channelizing activities and regulating activities, which later also can be followed up and monitored by the government. So, the power of the central government under first schedule and the fourth schedule also is similar. Then they may conduct auctions for grant of mining lease or a composite lease with respect to minerals specified in Part D of the first schedule. Then the registers of mining concessions need to be maintained. These registers need to be in writing, they need to be placed before the requisite authorities, and they may form a part of the report which is then sent to the legislatures for the purpose of assessment. There is the transfer of mineral concessions. Mineral concessions may be transferred from one person to another, and the person who receives the new leases or concessions, he would be having the same rights as the previous person. Then comes the rules for regulating. There are power of the government to frame rules, power to make rules for prospecting licenses, power to apply for minor minerals, power of the state government to make rules with respect to minor minerals, power of the state government to collect funds for the district mineral foundation in case of minor minerals, and the power to modify mining leases granted before 25th October 1949. The special powers of the central government to undertake prospecting or mining operations in certain cases and development of minerals. Special powers of the central government may be made for the purpose of operating or prospecting. Then they may also reserve areas for the purpose of conservation. Conservation requires that certain minerals need not be touched, used or extracted, because those are sensitive areas, or they are areas which, if excessive mining takes place in all areas at the same time, then our country would soon become devoid of all resources or all minerals which are used for running our daily lives. So, it is the slow and the systematic process which takes place. In that cases also certain areas may be considered reserved, and they may be protected and preserved for the purpose of making use in future dates. Mineral development may also take place in certain areas, that is, government may reserve those areas for the protection of certain minerals. That is, mineral development to take place in a manner which is not detrimental to the environment, but also promotes the reactivation or coming of mineral into a proper form, where development of it takes place for it to be made use of at a future date. The power to authorize Geological Survey of India to make certain investigation. Geological Survey Department makes investigations to see which areas are rich in what kind of minerals. They prepare reports and send them to the government for the purpose of assessment and for the purpose of the Mines and Minerals Act. Then comes the miscellaneous provisions. The mineral concession is to be void if it is in contravention of any act. Now, this specifically says that if a mineral concession is given and it is being illegally done, or there is a violation of a law which is considered to be illegal, then that mineral concession given, the government may withdraw that mineral concession given to that person. Then acts and rules which will apply to renewals of prospective licensing and mining leases. The government may apply certain rules and regulations which it has framed for the purpose of renewal of certain licenses where the lease and license of such minerals have expired. The power of the central government is also to issue directions with respect to various activities. If a person fails to conform to the same, he may be penalized to a certain period which may be prescribed or may be subject to fine or both in case it continues. The cognizance of offences. Offences, if it is they are made by certain officials or people, if they are made deliberately, then they will be penalized. If they are made not deliberately but without their knowledge, then they will not be punished. Same goes for offences by companies. If any offence is made deliberately by a company under the direction of its director or any officer or member, then in those cases the person who has deliberately made the same will be punished accordingly under section 23 of the Act. The compounding of offences, the power to search, the power of the state government to make rules for preventing illegal mining, transportation and storage of minerals, the power of entry and inspection, the rights and liabilities of a holder of a mineral concession, the recovery of certain sums as areas of the land revenue. There are delegation of powers which may be given from one person to another, and the person who is exercising the power will be doing so under the direction from whom he has delegated. The protection of action which is taken in good faith. The rules and notifications are to be laid before the Parliament, and certain rules are to be approved by the Parliament. The existing rules are to continue, then there is a power of revision by the central government. Special provisions relating to mining leases for coal may be granted before the 20th October 1949. Those leases will continue after the Act came into force. There may be constitution of special courts. Now, where the government feels the cases have received a lot of illegal mining or smuggling of minerals within that area, they may set up special courts for offences or for people who have been found guilty of the same and for speedy trials to take place. The special courts will have the powers of court of session. The Code of Criminal Procedure shall apply to the proceedings before the special court, and for the purpose of provisions of this Act, the special court shall be deemed to be a court of session with all powers of the court of session, and the person conducting the prosecution before the special court shall be deemed to be a public prosecutor. There are relaxation of rules in special cases. Central government, in the interest of the mineral development, it is necessary to do so by order in writing and reasons to be recorded, authorize the grant, renewal or transfer of any mineral concession or the working of any mine for the purpose of searching for mining any mineral or on terms and conditions different from those which are laid down under section 13. The section 32 has been amended in 1960 and the first schedule in 1960. So, the validation of certain acts and indemnity, all acts of the executing authority which are done, proceedings taken and sentencing passed under the Mines and Minerals Act of 1948 with respect to the regulation of mines and development of minerals during the period commencing from 1950 and ending with the date of commencement by the government or any officer of the government or any authority in the belief or purported belief that acts, proceedings or sentences were being done, taken or passed under the said Act shall be valid and operative, as if they have been done, taken or passed in accordance with the law, and no such suit or legal proceeding shall be maintained or continued against any person on the ground that such acts, proceedings or sentences were not done, taken or passed in accordance with the law. The schedules which have been mentioned under the Act are: the first schedule, which are specified minerals, Part A, hydrocarbons, energy minerals. The Part B contains atomic minerals and Part C contains the metallic and non-metallic minerals. Part D contains critical and strategic minerals. The second schedule contains rates of royalty in respect of minerals at items from 1 to 9, 11 to 40 and 42 to 55. The third schedule contains rates of the dead rent of the respective minerals. The fourth schedule, since it is a list which has been prepared by the government, the list could not have been incorporated in this presentation. So, the list needs to be referred to while studying the Mines and the Minerals Act of 1957, and as the amendments have taken place since 2015-16 and the current amendment of 2023. The fourth schedule contains the notified minerals: bauxite, iron ore, limestone, manganese ore. The fifth schedule contains iron ore and chromite, copper, coal and lignite, other minerals to the royalty payable on coal and lignite. The sixth schedule contains for non-auctioned captive mines other than coal and lignite, and the seventh schedule contains minerals. So, this is the scheme of the law which was framed in 1957. It continued up till a period of 40 years where several cases were brought before the courts for trial of disputed points relating to mining. Specifically, like the mining which took place in Dehradun within the city of Dehradun, it was leading to health and other issues within the city limits, to which the government and the courts had stated, giving directions to the government to shut down the licenses and the leases which were given for mining within the city limits, and to carry them or allow them to be carried outside the city. The new amendment which has been brought about in the year 2023 is also known as the Mines and the Minerals Development and Regulation Amendment Act of 2023. The MMDR Act of 1957 was amended in 2015 to introduce auction-based mineral concessions allocation for transparency, create a district mineral foundation for the welfare of the affected communities, establish a National Mineral Exploration Trust, which I have previously talked in my lecture, to promote the exploration and to impose stricter penalties for illegal mining. Now, this is very important. For example, taking the case of sand mining. With the development of the cities and more development as it is taking place, the cities require sand which is mined from areas which are naturally silted across the rivers, which are there as a part of the land in which people are living. There might be small mountains which are considered to be geographical marks by which people identify areas. All these are being exploited. If the government does not grant leases, it is taken away by the illegal people who conduct the mining and are transported to people who need that stand for the purpose of construction. The activities, both legal and illegal, have increased on a mass scale, which is having a detrimental effect on the environment. The Act was further amended in 2016 and 20 to address specific emergent issues, and it was last amended in 2021 to bring further reforms in the sector, such as removing the distinction between captive and merchant mines. The mineral sector required more reforms, particularly for increasing exploration and mining of critical minerals that are essential for economic development and national security of the country. The lack of availability of the critical minerals or concentration of their extraction or processing in a few geographical locations may lead to the supply chain vulnerability and even disruption of the supplies. So, the critical minerals have gained significance in view of India's commitments towards energy transition and achieving the net zero emission by 2070. The amendments which have taken place under the 2023 Act are: the private sector to the mine atomic minerals. It allows the private sector to mine 6 out of 12 atomic minerals such as the lithium, beryllium, niobium, titanium, tantalum and the zirconium. After it enters into force, the government shall have the power to auction the mining lease and composite license for critical minerals such as gold, silver, copper, zinc, lead, nickel. The exploration of the license auctions. The exploration license will be granted by the state government through competitive bidding. The central government will prescribe details such as the manner of auction, terms and conditions, and bidding parameters for exploration license through the rules which it specifically creates. The bill also allows areas in which activities are permitted. It allows activities under a single exploration license in an area up to 1,000 square kilometers. After the first 3 years, the licensee will be allowed to retain up to 25% of the originally authorized area. Explorative license, the incentives. If a resource are proven after exploration, the state government must conduct an auction for mining the lease within 6 months of the submission of the report by the exploration licensee. The licensee will receive a share in the auction value of the mining lease for the mineral which has been prospected by them. Now, if we look at the overall overview of the Act was brought into force at a time when several aspects of the mining activities were not really known or not really explored or not scientifically proven to be good or bad. From 1957 to the current date, the mineral law continued to exist as per the law which was there and which was ancient. It was only in the 1970s that development in India started taking place, and after the 90s it took place on such a rapid scale that it was difficult to keep up with the times. So, there was an increased need for the use of certain minerals which has multiplied several times, and in view of the population in our country, the needs and the uses for the same have also multiplied for them. Like the use of cars in everyday life of every ordinary person, every person needs a vehicle to go forth and back to his home after working, and he requires fuels for the same. So, the minerals which are there, although they are outside the purview, will also need to be explored as to how this never ending reason to make use of that will be followed by an alternative vision. Like today, currently we have the electric vehicles coming in view of the petrol minerals. So, it is in a similar manner it needs to be seen according to the changing times and the development of our country as it is taking place. The pressure on the use of these minerals for the purpose of extraction, use and reservation is not much as it is left because of the population which has increased over a period of time. So, the government needs to find policies which balance both the minerals as well as their protection and reservation, only make use of that amount which is so required and leave the remaining amounts and not allow excessive mining to take place in most of these areas. Now, coming down to the cases which have been currently there, I will only be focusing on a few cases which have brought about major landmark judgments in India with respect to mining activities. These are a list of cases which have taken place over a period of time where the government has passed orders in favor of stopping the mining and not allowing chemical activities to take place for the purpose of either pollution or exploitation or protecting the reserves, or those activities which are causing health hazards to both human and living beings in an area, or are prospective dangers to the ecosystems which are in and around these areas. So, these decisions which have been taken by the courts justify why mining should take place or why mining should be stopped in either ways. The remaining also are subsequent cases. I would like to focus on the case of Narmada Bachao Andolan versus Union of India. The Narmada Bachao Andolan case was a very unique case with respect to certain activities which are all interrelated. As I stated, the Mines and the Minerals Act is also indirectly affecting the Forest Act. It is also indirectly affecting the Wildlife Protection Act. It is indirectly affecting the Forest Dwellers Rights Act of 2000 and the Scheduled Tribes Act, and it also they are all interrelated, or the Biodiversity Act of year 2002. So, all these activities, when one activity is taken up, all other laws and all other related activities are affected in turn. Say if a mining activity takes place, it affects the tribals, it affects the forest covers which are there for the protection of areas, it affects the wildlife which is living in an area, and it also affects those who are indirectly indirect stakeholders in these areas, and the respective laws also apply to them. Coming down to the case of Orissa Mining Corporation versus Ministry of Environment and Forests. This was the sterilite industry, also known as a subsidiary of the parent company of Vedanta. They filed an application for environmental clearance for starting an alumina refinery project in the Lanjigarh Tehsil of district Kalahandi, stating that no forest land was involved within the area of 10 kilometers. Vedanta in this case had filed an application before the court seeking approval for the use of 723.343 hectares of land in this area. Noticing the forest land was involved in the state of Orissa, they submitted a proposal of 58.9 acre area land of the forest land, and the said ARP and the rest of the conveyor belt and the road which was leading to the mining site. The state of Orissa withdrew the proposal. The Ministry of Environment and Forests, as per the application submitted, granted environmental clearance for 1 million ton per annum capacity of the refinery at Lanjigarh on 72 acre land by delinking it with the mining project. Now, the Ministry of Environment and Forests considered the request of the state of Orissa seeking prior approval by the MOEF of forest land for mining of bauxite ore in that area, and they quoted section 2 of the Forest Act also. So, the Ministry of Environment and Forests granted clearance on certain grounds, which stated that it is a violation of the tribal, where the application or the case which was filed before the court stated it is a violation of the rights of the tribal groups, it is a violation of the Environmental Protection Act of 1986, it is a violation under the Forest Conservation Act 1980, and if there is valuation of that area will indirectly infringe on the rights of the tribals. So, these cases which are there are working towards protection of areas, interlinking all activities related to all other laws. Thank you.
Hi, my name is Gillette Sam and I teach sociology at IIT Kanpur. Today I want to tell you a little bit about what sociology is. In order to go ahead and study sociology, one of the things you need to develop is a sociological way of thinking. Now, this capacity to think in a sociological manner was termed as the sociological imagination by an American sociologist called C. Wright Mills in 1959. He argued that in order to think in a sociological manner, you should be able to have two different skill sets. The first skill set would require you to have the capacity to think beyond the problems that individuals face. So, if you encounter a problem that some one individual is facing, you should be able to connect it to a broader public problem. Mills gave the example of people in his neighborhood. He says if there is one person who is unemployed in the neighborhood, that seems to be an individual problem, but as a sociologist, you're expected to dig around a little. So you come across a couple of other people in your neighborhood who are also unemployed. That indicates to you that rather than being a specific problem, there is a larger public issue at hand. So as a sociologist, you're supposed to look at individual problems and see how they are connected to broader public issues. The second capacity that you're expected to develop as a sociologist is the capacity to link an individual's biography with history. Historical thought may not come to you as the first thing that's connected to sociology, but it plays a pretty important role in the field.